point of time, Government of India is of the subtle opinion that the dispensation of the Council is not commensurate with the Act, its responsibility discharge is not in conformity with the objectives, or in any case there is a substantial ground to believe that there is an aberration which has taken place in the functioning of the Council, a direct commission of inquiry can be appointed by Government of India to look into the conduct, public conduct of the Medical Council of India. The composition of that particular commission of inquiry is prescribed, that it is expected to be headed by a person not less than a retired High Court judge and a member nominated by the Government of India, and above all, that particular commission of inquiry is expected to be on the basis of summary trial. Sitting High Court judge, and the proceedings are expected to be on the basis of summary trial. These four I construe as reasonable checks which have been inbuilt in the system and have been time tested. But contemplate a situation, Chairman Sir, where directions are required to be issued in public interest and you don't even bother to define as to what public interests are. Such public interest as will be deemed appropriate by the Government of India. I can understand directions, Chairman Sir, but directions which will amount to what? Amount to dissolution of the Executive Committee of the Council, amount to removal of the elected President of the Council, amounting to removal of the Vice President of the Council, and amounting to removal of the members of the Council. This is exactly the contemplated nature of directions. Democracy will never be hearing an embargo which the Government of India wanted to put 2 elected terms for the members and no further. I appreciate the logic, but then this logic should be appreciated by Government of India to all the democratically elected bodies, and even if that be the case, Madam, the 3rd elected term of the Member of Parliament would not have been possible to the Honourable Member, Honourable Minister, who is a 3rd time elected Member of the Parliament. Embargoes, if they are required to be put in, there has to be a justification. Democracy cannot know the language of embargoes, and therefore it is an antithesis to that particular proposition. The concern which is expected is, what exactly is prompting? When checks and balances which have been time tested, when they have been effective, they have been in a position to be working out the situation absolutely in order, and not that. Dr. Abdullah said, I seek your attention. 1987, sir, a joint parliamentary committee came into being for the purposes of evaluation of Indian Medical Council Act Amendment Bill 1987. 39 suggestions have been made by the Joint Parliamentary Committee. That Joint Parliamentary Committee report is availed for the purposes of promulgation of 10A Amendment which has been brought out in 1993. I want to know what exactly happened to that Joint Parliamentary Committee report when the bill, Indian Medical Council Act 2005 Amendment Bill, was formulated by the Government of India. Therefore, autonomy just does not contemplate checks and balances. Autonomy is a state of mind which is required on part of the governing agencies. When you say that Medical Council of India and Professional Councils of India are expected to be responsible to the government, perhaps you are wanting to abridge that Lakshman Rekha which is expected to be subtle and is expected to be honored. And therefore, on behalf of the Medical Council and the professional community, I would like that Indian Medical Council Act, Amendment Bill 2005, is nothing but an antithesis to even barest of the bare concept of autonomy, which should be set aside lock, stock and barrel.